I grew up with a horrible stutter. But through college, whenever I had to give speeches or presentations, it was still embarrassing, a huge struggle. When that's your background, the last thing you think or the last thing you aspire to be is a trial lawyer. You're standing in front of the jury, the judge, everyone's got their eyes on you. It seems to be the last thing that I would have wanted to do.
Hey, what's going on, everybody? Joel Irway here, and welcome to episode number 143 of Experts Unleashed. I am super pumped today. I've got a very special guest here, and today we're going to be chatting with Pedro Krompecher, managing partner at Krompecher Law Firm. I'm excited to dive into today's conversation, and we're going to talk all things about his journey, his law firm, why he got started, and all sorts of fun things revolving around that. Quick bio about Pedro. Pedro is the managing partner at Krompecher Law Firm, headquartered in Raleigh, North Carolina. He handles workers' compensation claims and catastrophic car wrecks. And a significant part of his practice is built around hiring and deposing experts, both in discovery and at trial. I hope he doesn't depose me here today. But anyway, before he opened the firm in 2012, he spent close to a decade on the defense side, training under one of the most respected trial lawyers in Chicago. And he's since gone on to try over 100 cases and recover more than $100 million for his clients. Pedro, welcome to Experts Unleashed, my man.
Thank you. Thank you. Happy to be here. Appreciate it.
Yeah. Well, let's get started. And as we were chatting before, one of the things that I found was that you went to school in Syracuse, which is right down the road from where I'm located. I grew up in Rochester, which is about an hour and a half. And actually, one of my sales territories back in the day was Syracuse. So you played soccer in Belgium. I studied economics at Syracuse, law school at Loyola Chicago. When did you actually know you were going to be a trial lawyer?
So if we back up just a little bit, I was
Yeah.
an economics major at Syracuse, and this goes back to 2001, 2002-ish. And I did not want to go into banking, which is the job that I was offered. And I had a good banking job lined up in New York City, but decided I'll just take the bar or the LSAT, apply to a bunch of law schools, and just see what happens. And I ended up getting to Loyola in Chicago based on you had to get recommendations to complete your law school application. So you had to get some. I mean, I wasn't working; I was in college, so I got professors and people on the boards and stuff. And this lawyer told me, he said, go to law school in this city where you want to practice law. So that's how I ended up at Loyola in Chicago, because I didn't get into Northwestern and I didn't get into University of Chicago. So I went to Loyola and I was just buying time. The people in law school are so smart. And it wasn't until I took a trial advocacy class, I guess my second year in law school, where for the first time I didn't feel like the dumbest person in the class. And for the first time I felt like, this is actually pretty easy for me. And shortly after that class, I realized I was either going to do trial work or I was going to have to find another job. I'd have to go into banking or something, because it just wasn't, the academics were, it was not going to be a situation where I was going to spend more than a couple of years in a corner office before I was going to, ditch the career. So, I figured it out before I graduated law school. And then I had to figure out how to get a lot of trials in my belt and how to work for good people. But that's when I figured it out. It was like my second year of law school. I almost dropped out of law school. I mean, I wanted to. If it wasn't so expensive and I had so much debt, I probably would have dropped out of law school.
Well, you targeted Chicago. Why Chicago? What was so top of mind for you there?
So, big city, a lot of clients, good airport. I grew up in Columbus, Ohio, so it's our New York City. I knew tons of people there from high school, and it felt like the the competition there was not as significant as New York or even Washington, but you still had all the major law firms. And so you had pretty good opportunities. And not ironically, but I guess prophetically, when I got the job at this large law firm, a job I probably shouldn't have received, it was because the managing partner went to Loyola. And he said, I'm tired of all these Harvard kids and all these other people. I went to Loyola, and that's a great school, and I know the teachers there, and I know your education, and we need more people from Loyola at this firm. And that's how I got the job. I mean, I made myself in the in the door to the interview, but that's what landed me the job. The same advice that lawyer gave me at Syracuse actually worked out. It panned out.
Well, I think it's interesting. You said that it's got one of the best airports. I can't stand flying into Chicago or out of Chicago, so
So
we might debate that another
if
time.
you
But
go, if you only fly out of Midway, you can get to anywhere on a direct flight. I only
that is
fly
true.
direct because of there's too many variables when you're connecting. And so now I live in Raleigh. I have some decent options, but not the Chicago options. I could go direct anywhere in the city or anywhere in the country.
Yep. I got you. So it's definitely convenient. Certainly convenient. I just always have a very hard time not getting delayed or canceled out of Chicago. But anyway, I don't want to derail the conversation, but so that's fascinating. Okay, cool. So now getting into practicing law, right? You spent close to a decade defending hospitals, nursing homes, large corporations. Is that correct?
Yeah, so that's all we did. I worked in a real big firm. I worked for three partners. One partner did almost exclusively nursing home work. Another partner did all medical malpractice and hospital work, and then another partner did commercial litigation. And they just happened to be on the same side of the same floor. And so I started with one group, and they start passing you around if you're any good. So those were the groups that I worked in. All defense work, insurance company defense work, higher end stuff. It was birth injury cases and stuff like that. But yeah, I mean, it was high end litigation from the beginning.
Well, so I think this part is fascinating because you're on the defense side. Okay, so totally different side. What did you learn on that side, and was there a moment that caused you to switch to the other side of the table? Like, give us a little bit of context.
Here's the big difference that the majority of the people who are not practicing law don't understand. Plaintiffs, lawyers that represent injured people, we get paid on a contingency. We get a percentage of what we recover, right?
Hmm.
When you're on the defense side, or you work for a bank, or you are getting paid by the hour, right? So the motivations of the two sides are very dissimilar. As a plaintiff's attorney, you're fronting all the expenses, right? You're not getting paid by the hour, and so a lot of times you're spending extra time that it's hard to calculate the ROI on traveling all the time in the airports when the defense lawyers are getting paid hourly to do all that stuff. So they're happy to do it. And so it's two totally different mindsets. And
Hmm.
and here's what I would here's an example. You get out of law school and you go to a good litigation firm, but I mean, insurance companies are essentially massive clients with endless money, right? You can justify the expense they're willing to pay. And so you get paid to learn. If you're good, they'll send you to depositions and all kinds of things. And even when you're holding somebody's briefcase or who's holding somebody else's briefcase, you're getting paid and the firm is getting paid. And so when you start on that side, you get to do so much more because when you're on the plaintiff side, they're going to want the best people doing all the litigation, right? They don't want a junior guy to take any depositions because it's not his case. But
Hmm.
at a defense firm, the incentive is to build a pyramid, right? The incentive is to get more work and have more lawyers underneath you working, churning and billing. And so you get to do so much. And then when you land with with the right mentor, he's happy to bill his clients for all your time, and you get the benefit of being paid to learn.
Hmm.
So that's the difference, right? And what changes for a lot of people is whether you can tolerate risk or not, right? That's a lot of times what happens. And so for me it was different. I ended up doing it because when we moved to North Carolina, I was doing defense work here, and my wife, I was traveling too much. And the only other option I had was to be a plaintiff's lawyer. Because as a defense lawyer, everybody was doing the same thing. Everybody was
Hmm.
flying around the country because Raleigh's too small, right? You have to have clients in several states. And so I switched out of a requirement from my wife that said, you travel too much and I want to start having kids. And that was the only option I had. I had met and learned from her. I, tried cases against so many plaintiffs lawyers that they said, just come and be a plaintiff's lawyer. We'll give you our med mal cases. We'll give you that stuff. And so when I came over, the value was I had so much litigation and med mal trial experience and deposition experience and expert experience that other plaintiffs lawyers were giving me their nursing home cases and were giving me their brachial plexus birth injury cases. And so that's what I started doing. It was a result of having a lot of experience in the trial room and in experts from the decade of being a defense lawyer. It wouldn't have happened the other way around.
Did you find that transition easy or simple, like as you made the transition to the plaintiff side?
So it's just the same as working for a company and going out on your own in any industry, right? You shoulder all the risk, right? It's just, you're a baker, you work at Wegmans, and then you go and open your own bakery. It's the same thing, right? And so, yeah, it's scary. I didn't have a choice. What I did, or what we did, we had, my wife and I took all the money we had and we divided it into 12. And that was my advertising budget. And it was like, I don't know, something ridiculously small, like $2,500 a month or something like that. Advertising budget, because then I had to rent a little office at my buddy's law firm and all these things. And I remember the first case I got paid on was on month 11. And I had the first year I had to start making money. That was the deal with my wife. You get the first year off. Month 13, you got to start making money. And we were so happy. I drove that check out to the taco stand he was working. He had like an hour and a half away from Raleigh. So it was super scary. But once it starts working, you're just betting on yourself, just like a baker leaving. I mean, you're just betting on yourself. And at some point, you look around and you say, I think I'm better than everybody else here at doing this job. So that's what happened.
Sounds like risk appetite is one of the primary requirements of making that switch from defense to plaintiff, right?
100%.
Yeah. What about strategy? Now, with what you learned on the defense side, applying that to the plaintiff side, what were those transferable skills and what were some of those new skill sets that you might have had to develop switching sides of the table? Or maybe it was all the same.
Well, I'll give you a perfect example.
Yep.
The first case when I left my defense firm, I I took with me one case. This is not how you start plaintiffs firms. You don't start plaintiffs firms without clients, right? You start
Hmm.
plaintiffs firms, you work at another plaintiffs firm, and you leave with 30, 50, 60, 100 clients to start your own firm. I left a defense firm with one client. And the one client was my in-law's best friend. And my in-law's best friend slipped and fell in a chain steakhouse right when it opened up, and she broke her hip. Okay, and this case was going to be great. And so I was litigating all these big medical malpractice cases where we would have 20 experts at a time. I mean, 20 experts. And so I leave with this case, I don't settle it, and I have to go to trials. My first trial as a plaintiff's lawyer. I think I took 13 depositions in that case. 13 depositions on a slip and fall at a, I don't know, steakhouse. And the trial took a week and a half, and it was a hung jury. But the point of the story is I tried that case like a defense lawyer, right? I actually ended up losing because of the hung jury, and I had so much money in case expenses, all the depositions, and I hired experts. I mean, it was crazy, right? And so I learned that lesson really tough. Not only did I lose the case, but I lost $23,000 I did not have in case expenses. It was a tough learning curve.
How did you apply that to your next case? Meaning, okay, cool. First one, swing and a miss. Next one that comes up, what was the next?
First one I tried like a defense lawyer, right?
Yep.
I tried every fact and I had everything and I knew what everybody was going to say and all this BS that is really a waste of time, right? As defense lawyers, you just have to convince one juror. As a plaintiff lawyer, you have to convince them all, right? And so the defense job is so much easier. I know I did it for 10 years, right? I probably tried 50 defense cases in my practice cases. And the point being is that as a defendant, you want to throw everything up against the wall. The more facts, the more witnesses, the more people, the more stuff that the plaintiff's expert has to explain. And so a defense lawyer wants to take as many depositions as possible, wants to get all the documents, scorch the earth, because his or her job is not to connect all the dots. All they have to do is take one dot out of the string of dots. And so the more dots they put up on the wall, the more beads you have to thread through, the more difficult. Would you rather have 3 dots you have to connect or 12? Right? And so that's the difference. And so as a plaintiff's lawyer, I've tried almost 50 cases as a plaintiff's lawyer too. I've probably tried almost the same amount. And it's totally different, right? You want to focus the case because you only want 3 dots to connect. You don't want 12. You want 3. And so you have to try your cases totally differently. So differently. And, you can go to all these places that I went to and fly around and take all these courses and read all these books, right? But at the end of the day, you have to try cases. You have to try cases. And eventually it's like, I don't know if it's riding a bike, but eventually you've done it so many times that you're not worried about making mistakes anymore, and you can actually think through the trial. And the same thing in depositions. But you can't go in and spend all this money because you'll have $30,000 in expenses in a car wreck case that's worth $75,000. If you want to stay alive and make enough money, you can't run those numbers. It doesn't work.
Well, one of the things you mentioned as you were talking is that you need to develop kind of a system or a process. And I know you sent over a case study before our interview,
Yes.
and you have a process. Like you have your own kind of methodology. Can you walk through that?
Yeah, so preparing for this meeting, this interview was a great thing because I had all these depositions in this case I just settled. I actually settled this case yesterday, set for trial on Monday. Double fatality case, horrible case. But we just got done with all these expert depositions. And so I had all this material, my outlines, basically my work product of the process that I do. And what I did to prepare for this was I dumped everything into one of the chat bots that we use. It's my Claude cowork. And I said, look, I want you to break this down into my system. Because I don't have this like note card. This is a system that it's just now how I do things. And so it took all my work in these depositions and it saw my outlines and everything. And it came up with these bullet points and this strategy that I apply on all of my cases. I do them all the same. But I don't necessarily think about it as step one, step two, step three, step four. I think about it as these are the steps that you have to go through to understand the case from the perspective that I want to understand it, right? It's just you have to do it this way to get the
Hmm.
results. And so in this case, so this is a great case to talk about because this case would have been, had I tried this case 10 years ago or 15 years ago, it would have been a mess. So I only took two depositions. I'll give you a quick summary of this case. It's
Yeah,
pretty fascinating, pretty
please.
fascinating. So let me see here really quick. I've got a good little summary here for you about this case. So this case happened in on December 27th of 2022, and it's a one-way road, so it's a one lane in each direction, rural road, and my clients are two Hispanic, a father and son, and 19 and 49 years old, and they are coming to a stop two cars behind a lady who has stopped waiting for traffic to pass to turn left into her driveway. My two clients, Juventino and Juan Carlos, they were in a pickup truck and a commercial vehicle hit them from behind, but trying to avoid the impact at the last minute, turned to the right and knocked their vehicle in onto oncoming traffic. And bing bang, it was less than a second, bang bang, a dump truck coming the other direction with a dash cam kills them both instantly, right? And so I only took I I sued the driver of each one of the commercial vehicles and their companies, and there must have been 10 different witnesses at the scene. But we had the black box, we had the Bendix, we had these are all sensors that tell you throttle, driving, direction, all these things. And so we had that, and we had the dash cam of the dump truck. And so I had to make a decision if I was going to solve every mystery or just boil it down to the core parts of this case because I had two defendant lawyers with their teams, right? So there was a lot of other people that were trying to make this a big deal. I only took two depositions, the deposition of each one of the drivers. That's it. Nothing else. And that kept the case really, really narrow. I hired five experts, and the way that I went about the case was I had a loser case against the dump truck, a loser case. I showed it to so many of my buddies, so many lawyers. And I would say, what do you see here? The dash cam. And they would say, that's so horrible. I would say, do you think this uh, dump truck driver could have avoided it? I'm not talking 9 out of 10. I'm talking 99 out of 100 people said it's not avoidable. It's a bang bang. But they had commercial policies, and I had two fatalities. So I hired a bunch of experts. I hired two experts in each field, and I ran the videos by the experts and they did their accident reconstruction, and I was not satisfied. It sounded weak. It was a pretty.
Hmm. 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 Well, let me ask. Yeah, let me ask you. So 1 out of 10 hours, what's acceptable? Like obviously that was enough to get them to settle, correct? Before going to trial. Am I
Yes,
understanding that correctly? So
totally.
what would be acceptable? Like what obviously you presented that data as unacceptable or high risk or something to flag it. What is acceptable then?
Here's the interesting point on that issue. The defendants in this case only hired one expert. They only hired an accident reconstructionist. They did not hire a trucking safety expert. And so when you have these issues that fall outside the scope of the adverse expert, then your experts get to go unopposed. And so what happened here was we had one of my trucking safety experts was amazing, incredible. And he knew he had forgotten more about the regulations than the defense lawyers ever knew, right? It was that much of a disparity in knowledge. And so you can tell that they didn't have an expert prep them on the questions. I also have my experts help me draft my examinations of the adverse experts. I mean, these are drills we did. I mean, these are how we did it as a defense lawyer. We would always hire as many experts as we could justify to our clients because you can also do the strategy that I employed in this case, and I do it a lot now, is as the plaintiff, right? I go first at trial. I have to put on the evidence first. I have to meet my burden first. So when you're agreeing pursuant to court order, but a lot of times by agreement, when you have to disclose your experts to each other, when you get to depose the other side's experts, the plaintiff's experts traditionally go first because that's the course of the that's how the evidence moves throughout trial. So the plaintiff goes first. So retaining two experts in each field, and then I had an economist for lost earning capacity. But in this case, having two experts in each field, they say, give us dates for the depositions of your experts. And so we can control who goes first and in what order. And so I put the weakest accident reconstructionist first, and then I put the weakest of the two trucking safety experts first, and I make sure I order those expedited, and I send those to the two stronger experts, and they get tremendous benefit from doing it that way. And so not only do I have two experts, I say, or commonly we say, you have two bites of the apple. Because if you only have one expert and that expert bombs, you're in trouble. You're in big trouble.
Hmm.
Because by the time you figure that out, there's very little opportunity for you to justifiably say, I need to go hire a new expert that I've never disclosed because my expert sucked. That's not really an excuse. So we always had multiple experts. In this case, they didn't have multiple experts. They didn't have multiple accident reconstructionists, and they didn't have a trucking safety expert. So the litigation strategies in this case, I think, were very effective. But we did not settle the case until Thursday before Monday trial. And we had 5 experts flying in. So part of this game is once you get to the point of deposing the experts, actually putting them under oath in front of a video camera, most cases where you're going to have multiple experts, you're doing this within the last 30 days before trial. That's the reality of it, right? And so a lot of times people don't get to that stage in the litigation before they resolve the case. And so it's the last thing you learn when you think about it. Right? A lot of the last things you learn are the trial, and then motions in limine, and then expert depositions, because as a junior lawyer, you're not going to get those opportunities. And as a mid-level associate or a senior associate or a junior partner, right? You have to start making decisions for your clients. And so a lot of people don't get that far in the litigation path. And that's why a lot of people struggle when they do get there, because there's a lot of things to consider. And if you're not there often, then it makes it really hard.
Yeah.
I got burned 1,000 times, right?
Well, let me ask you this. It seems like when you first took on this case, your confidence was very, very low as all the data started to come out, and there wasn't a whole lot to look forward to. So if 10 different plaintiff lawyers took the case, how many do you think would have actually settled or won the case, knowing that you won it, right?
So I settled it, right? I settled it before trial. So we came to an
Mm-hmm.
agreement, right?
Yep.
Versus a jury telling me how much money I get, or that I am entitled to nothing. Here is what happened. The video, so in litigation, commonly you fly around and go to these events, and everybody talks about doing focus groups, and they're expensive, they're tedious, for a million reasons. They're just difficult, right? It's just like trying to get your kids to take out the trash. It's just not worth it sometimes. It's just so much work. And so, but you could always, especially nowadays, right? If I have a video, I'm showing everybody I play golf with. I'm like, what do you think about this? Just seriously, what do you think about this? And I have good relationships with some of the older guard in North Carolina. And one of the lawyers that I've worked with on a bunch of really big cases. He's 75 years old. And I went down to his house 2 hours away from Raleigh. And I took him a bottle of booze, and we sat and had lunch. And he had his little handlers around him. And he's got a nasal cannula, and he's hooked up to this air cord. It's 300 feet long, so he can get all around his house. He's outside. He's smoking cowboy killers with his nasal cannula, having a bourbon while we're talking about this case. And I said, Wade, I need you to tell me how I'm going to try this case. And he thought it was a loser from day one. But by the time I got to, this is 3 or 4 weeks ago, I said, Pedro, how long to the trial? About 3.5 weeks. It was perfect, right? And so by the time I got done telling him what the data was going to show about the Bendix system, he went from thinking my case was a loser to thinking it was a 100% winner. And the reason we didn't end up going to trial was because of all the available commercial insurance policies. We got just over 85% of all the money available, all policies. And so the delta wasn't sufficient to take the risk of a bad juror or somebody that hangs the case up. So we ended up resolving the case.
So my initial question though is, I want you to compare yourself to maybe 10 other plaintiff lawyers, right? Had they taken it,
Why I kept it? Why I didn't punt on the case?
So So I want you to brag about yourself a little bit. Okay.
Okay.
So, because of your thorough investigation and uncovering all this data and getting to that Bendix, how many other plaintiff lawyers do you think would have gotten to that point versus, you know, the alternative?
So we were talking before this show that to be a plaintiff's lawyer, you have to have an appetite for risk,
Mm-hmm.
right? And so this is a risk calculation, right? And so I looked at it as saying I had a 50-50 chance at winning liability against this dump truck, but they had a big commercial policy, right? And so if I have a big commercial policy, I'm going to take that chance. Even if I have $35,000 in expert expenses, I'm going to take that chance. And so holding on to cases all the way through at the end sometimes is very rewarding. And sometimes in hindsight, you look like an idiot. Because if my experts didn't find this stuff, hindsight's 2020. At the time, it maybe was more risky than it ended up being. But taking the risk and being okay with spending money on yourself is a big deal that differentiates a lot of plaintiff lawyers. Everybody is reasonably intelligent who has some success as a trial lawyer. And so the difference from that point on has a lot to do with your appetite for risk. Because if you don't inherently have confidence in what you are doing and your abilities, you're never going to throw a bunch of money behind your case because you really think you're probably going to lose, right? And so you can't justify spending 20, 30, 40,000 dollars on experts on all this capital that you need just to meet your burden because you're thinking about the chances of losing the entire time. And so that's the first why in the road, right?
Mm-hmm.
That's the first step where if you don't have a high tolerance for risk, it doesn't matter. You're going to work for somebody else if you're going to be a plaintiff's lawyer, right? You're going to work under the umbrella of somebody else. It's not going to be your shingle. And so once you go off to that side and you have a tolerance for risk, the next thing I think is how competitive you are. And that's why a lot of trial lawyers are good athletes. I thought it was a coincidence. It's not. A lot of good trial lawyers like to play golf because it's so competitive. And I played pro soccer after high school. I went to Belgium and played in the Belgian league for a year and a half before coming back and going to Syracuse. And so I had this uber competitiveness about me from playing soccer. The other thing is I think it's important on top of being competitive and on top of having an appetite for risk, you have to have a chip on your shoulder. You have to feel like you're there to prove yourself to everybody else, or you're not going to have what it takes. That last 20% is the hardest, right? The 80-20 rule. That last 20 takes 80% of work to accomplish that last 20%. And it takes 20% to accomplish the first 80%. And so you have to have all those three things. When I try cases, when I litigate cases, I look at my adversary the same way I did playing professional soccer, 100%. It is just one-on-one combat. The thing that used to differentiate trial lawyers was their resources. You work at a big law firm, you have a bunch of associates, you have a high billable rate, you have good clients. You could spend money on associates getting you all the research you needed, right? Now, with AI and all the tech advances, you're leveling the playing field, right? So we have more lawyers than you is worth much less than it was even 6 months ago.
Yeah.
Even 6 months ago. I mean, my outline for these for this accident reconstructionist was hundreds of pages, and it was broken down several stages in several groups. All this stuff you can manipulate now so easily. But before, it would have taken me, I would have been preparing for that deposition for a week. Because I would have had to go to the library and pull all the statutes and all the regulations and learn all the shit that I had no idea about, right? I mean, I've handled a ton of trucking cases, but every case is a new case to me. And so I'm not burdened by memory, which means when I get another case, even if I've had a bunch of them, I'm getting all the way back in it again. So you have to be okay with losing.
Yep.
Trial lawyers that say they haven't lost a case, or they only lose 1% of their cases, or 3% of their cases, or 10% of their cases, those people don't try cases. It's not possible.
Yep.
It is not possible. You know, I don't think people should be able to call themselves a trial lawyer until they've tried 20 jury trials. Like, you have to have that as part of what you're doing. And so it's a mental game, it's a competitive game. And then the last thing out of all this is going to blow you. Well, I don't know if it's going to blow your mind or not, but I grew up with a horrible stutter. And by the time I was in high school, I had managed it pretty well. But through college, whenever I had to give speeches or, presentations, it was still embarrassing, a huge struggle, even though I had advanced significantly over the years. When that's your background, the last thing you think, or the last thing you aspire to be, is a trial lawyer. Right? You're standing in front of the jury, the judge, everyone's got their eyes on you. It seems to be the last thing that I would have wanted to do. And the reason I do it, if you go back that far in my life, is because it's so hard for me to be able to speak without a stutter, that I'm so dialed in to everything I say, because I have to think through every word that comes out of my mouth, even now. And so the trial aspect, the way I feel when I'm getting ready for a big deposition, is the same way I used to feel before a professional soccer game, right? It's the same thing. And so that's the chip on your shoulder, right? It's the same thing that made me a good athlete. It wasn't that I was a better athlete. It's that I had a huge chip on my shoulder, huge mental advantage, or a mental advantage, because I was so prepared to do everything I had to do. I was certainly not the best athlete. I'm by no means the brightest lawyer. But being a trial lawyer, they say all trial lawyers were C students in law school. I was better than that. But the point being is that I believe if you're too intellectually committed, if you're tethered to an intellectual exercise, and or if it's important for you to feel, to represent how smart you are to other people, you're not going to be a good trial lawyer. You have to be able to dumb things down. You have to be able to speak in a much more regular, normal way. And that's really hard for a lot of very intelligent people.
I think one of the key things that you highlighted, which should be placed to the forefront, is that obviously your personality trait of being an ultra competitive athlete translated very well into being a trial lawyer. And I think that's a very, very critical distinction. You need someone to fight. Like, you need someone to go to battle, and you need someone to not cower when the cards are stacked against you. You need someone to dig. You need someone to think through things. And I thought that was very unique with your background and translating that to what you do now.
But I will tell you, over all the years traveling with all these other litigators, when you fly to go to these depositions, everyone's staying at the same hotels. And I will tell you, the vast majority of successful trial lawyers are very accomplished athletes. Mm-hmm. And a lot of them still wake up at 4 o'clock in the morning and run. The majority of the very successful trial lawyers that I have worked with, that I know, work out at 4:30 in the morning. Mm-hmm. They're fanatical. That's just how they're wired. So I don't think it's coincidence at all. I do think it gave me an advantage, but at a certain level of trial lawyers, the other ones have similar backgrounds.
Yep.
Right. Everybody has a chip on their shoulder when they're there. If not, you don't have that. I don't think you have the grit that it takes to do that job and to take the risks of losing all your time and money.
I agree. Yeah, I think there are very, very clear common personality traits and common themes based on what you're sharing. Um, Pedro, where do you find your clients right now? Is it mostly through referrals? Are you like,
No.
do you advertise heavily?
Yes, I do. We haven't talked about this, but I I when I decided to be a plaintiff's lawyer, I knew I needed an advertising budget, and that was 2012. We took all the money we had, we divided it into 12 months. I took $1,000 for a little office and a phone at my buddy's nice law firm, and they put me in a corner. And and I started. It takes a long time to break into advertising, but at the end of the day, there's only two ways to get good cases. You either advertise a lot and deal with the filters, or you work by referrals, meaning other lawyers that may not do that specialty or do that specialty and don't have that level of trial experience, or do that specialty, have that level of trial experience and don't want to try cases anymore. And they will refer cases to other people. I get referral cases from five or six lawyers, and I get them when it gets into expert depositions.
Mm-hmm.
And but 99% of my cases come from television advertising, billboards, radio, digital, all those things. And so, in plaintiff's law, we don't have repeat clients. I mean, now I have clients that have had 2 and 3 wrecks with me over the years, or 2 or 3 workers' comp cases, but they're not repeat clients. It's not a bank. It's not an insurance company. It's not a hospital, right? And so you're always scrapping for the next case, the next batch of cases, right? The next trial. There's no guarantees when you're a plaintiff's lawyer. Every month is a new month.
Yep.
Start from zero. Every month we start from zero here.
So 10 years from now, when someone thinks or says Krompecher Law Firm, what do you want them to say? What do you want the first thing out of their mouth to be?
The first thing out of the mouth that I would want them to say, or I hope they say would likely will, is, that guy is Abogado Pedro. That's the first thing I want them to say. And they will say. And the reason is 99% of my clients are Hispanic in North Carolina. And having that population, giving them access to high, sophisticated level trial lawyers has changed so many lives. We have over 7,000 clients that we've helped, made tons of money, but helped out people who don't have as many options as a traditional injured client have. And so being able to help people that really have tough jobs, make a lot lower wages, to change their lives when you can. Unfortunately, when you're changing somebody's life, it's because somebody was injured so much that they're getting a lot of money, right? So the worse the injury, the more the money normally. But just as somebody who was willing to take Hispanic cases to trial, right? When I started trying, of all the cases I've tried as a plaintiff's lawyer, I think 100% are no, not the first case. 95% are Hispanic clients in counties that are not very sympathetic to the Hispanic population. And so it's been 12, 13 years of doing this. That's what I do here. And that's something that I'm proud of, because I know all the trial judges and all the other lawyers, and it's a niche that I have been able to attach to. It's very satisfying. And and so as somebody that litigated a lot of cases for underprivileged Hispanic people in North Carolina by just trying cases, right? Just by doing the things that people shy away from doing.
Yeah. Well, it's really important that you niche down. I run my own marketing agency. I know the critical nature of that is carving out your own niche and focusing on that single specialty and owning it to the best of your ability and building a brand in it. So I think that was very, very wise. Pedro, this was fantastic. I really enjoyed
Thank you
this
so much.
conversation. There was a lot that we covered. I love the link to your soccer background. I think you and I can debate still on the on how well you love the Chicago airports. But no, I kid. But where can people find you? Where can they reach out to you? Where can they
So they
find
can
your firm?
find me at krompecherlaw.com is my English website. My Spanish website is abogadopedro.com. So ABOGADOPEDRO.com. And you can just Google me and you'll find stuff on YouTube and ways to get a hold of me. Yeah, so that's it.
Awesome. We'll make sure to include those links in the show notes down below. Pedro, I appreciate it. And for those of you listening, make sure you reach out to Pedro, let him know you heard him on Experts Unleashed. And until next time, we'll see you on the next episode. Take care.
Take care. Bye.